My name is Farah Faizal, and I am a retired diplomat from the Maldives. Now, the key words is retired and Maldives. I'm indigenous Maldivian. So we have our own language. It's only spoken in the Maldives. We have our own script, and we have our own culture. Now, I want you to cast your mind back, those of you who are old enough, because I can see a lot of faces who are very young, to 1987. It was in 1987, I was a first-year student of international relations here in the UK, when my president, the then president of Maldives, Maumoon Abdul Qayyum, got up in the 1987 Commonwealth Heads of Government meeting in Vancouver and said something. Now, this was before the Rome Statute. This was before the UNFCCC process. And he got up and he warned the Commonwealth and the world that rising seas and ecological damage threatened human life and culture and sovereignty. And his appeal marked one of the earliest moments when a state linked environmental destruction to human survival, a theme which we are just talking about here today. Now, that was 38 years ago. Now, I don't have 38 years more to come and chair sessions in panels like these or attend conferences. So I want, while we talk about ecocide, human rights, and environmental justice, I just want to appeal to all of you to remember that this is a lived experience for 38 years for me and my people. So there is an urgency here to do something. So please bear that in mind when we talk about it. Now let me revert to the panel. We're going to be talking about human rights and environmental stewardship. And at its heart, the discussion poses a profound question. How should human interests be weighed in relation to the environment? While ecocide has been conceived as a tool to protect ecosystems from severe harm, its definition itself continues to provoke debate. Does incorporating human well-being risks reinforcing the anthropocentric worldview that has driven environmental destruction? Or does excluding human concerns risk alienating the very communities most affected by ecological harm? And I have a distinguished panel here today with us. So I'm very excited to hear what they have to say. What I'm going to do is I'm going to introduce each panelist and let them talk to you. And then I will go to the second one. Just one word of caution. The retirement of the diplomat means I love being undiplomatic. You have 7 to 8 minutes, and if you run over it, I'm going to enjoy showing the undiplomatic side of it. Our first panelist is Dr. Lovleen Bhullar, who is an assistant professor in environmental law at the University of Cambridge, whose research focuses on the intersection of environmental law, human rights, and sustainable development. At this conference, she's joining us to speak on the theme, Reviving India's River Goddesses, Ecocide, the right to a healthy environment, and rights of nature. And I'm going to let her tell you a little bit more about the topic.
Excellent. And thank you to the organizers, and my time starts now. So first of all, a big shout out to my co-author, Ms. Geeta Parihar. She used to be the head of legal for Friends of the Earth, England, Wales, and Northern Ireland, and is now an independent consultant. And fun fact, I did an internship with Friends of the Earth many, many years ago, and she was one of my bosses. So this paper is written with two people who have a bit she has a lot and I have a little bit of practice experience trying to think about what all of these concepts might really mean on the ground. How do we operationalize ecocide, right to a healthy environment, and rights of nature as a composite, especially in a country like India? And the other thing we try to do is, rather than focusing on rights of nature or rights of environment, we took one particular component, rivers. And I think what we realized is the messiness of even trying to deal one of the components, which shows how difficult, what a complex exercise this is going to be actually. All right, so I'll offer my conclusion first, because I run out of time later. And really, kind of key message is to kind of really embrace pluralism. And I think it's a point that was made repeatedly in the first panel today. Pluralism in terms of the concept itself, ecocides rather than ecocide possibly, depending on where we are, context matters, and I think this point was made extensively in the first round. The environment is a subject or object. You know, we've talked about anthropocentricity and ecocentricity. We've also talked about interdependence, but it seems like there's a whole spectrum of possibility. And while conceptually we can talk about the anthropocentric, ecocentric divide, in practice we might have to be more creative and to appeal to the decision makers, offer a bit of anthropocentricity while making sure that the environment is protected quite effectively. So I think we sit somewhere in the middle on that spectrum. The third kind of pluralism perhaps is to think about multiple levels. Again, a point made earlier, international law, regional law, domestic law, but also subnational law possibly as the site at which we should be thinking about the intersection of ecocide, right to a healthy environment, and rights of nature. Pluralism of laws. This is not just about criminal law incorporating environmental factors or environmental law thinking about criminal law as a mechanism, but also other sides like companies law, procedural laws, etc. And a point that was made earlier about thinking beyond the law. So perhaps we need to think about law at the intersection of these three elements, but at the same time, the possibility that we need to also do things outside the law. I don't mean illegally, perhaps semi-legally sometimes, depending on how one looks at protests, but the multiple sides of resistance in that sense. And then finally, pluralism in terms of people. We've talked a lot about indigenous peoples. We also talk about local communities and the recognition, especially when you look at it from a rights of nature perspective, that your relationship with nature, for example, in the UK, is likely not to be based on you being from an indigenous community, but being a member of a community, which might have a certain relationship, say, with water, or for other reasons. And I think all of that needs to be kept in mind. I won't tell you what ecocide is. I think all of you know that much better than probably I do. What I can tell you is that India is not a signatory to the Rome Statute. So even if a crime of ecocide was to be recognized, as matters stand, India has no obligation at all to think about it in any kind of meaningful way. Which then very automatically led us to think about, what about domestic crime of ecocide? And that's where a lot of our paper is focused. What is also interesting about the other two elements, the right to a healthy environment, is that actually India is a country that recognized the right way before a lot of the international recognition of the right took place. Back in the late 70s, early 80s, we were already talking about a kind of a right to a healthy environment. The other thing that has happened in India, perhaps before many other jurisdictions, is rights of certain elements of nature. For example, rivers in a northern state of Uttarakhand, with the caveat that the Supreme Court actually stayed that order because the state government went to the Supreme Court and said, we just don't know how we're going to operationalize this concept. But what did happen is, it led to other high courts in other states saying, actually, there are other components of nature that deserve protection. A lake in one case, for example. So basically the point is, it's a prime ground to think about how we could bring at least right to a healthy environment and rights of nature together, and most importantly, ecocide. And I remember Geeta and I having a lot of conversations about what does the term ecocide mean in different languages in India. And we have more than 100 languages. But what it eventually means is the death of ecology, the death of the environment, and it seems that is what it's all about. And the death of the environment has been taking place in India and in other jurisdictions for centuries. I mean, I think it's been very well illustrated earlier, which means that for a very long time in different ways, decision makers have also been thinking about how to deal with that death. They haven't done a very good job, clearly, because pollution's gotten worse. There is more biodiversity loss. and we have climate change issues, but there is something there in the legal system. So what is there in the legal system in India? Firstly, we have the Constitution of India, which many of you may have heard about. We don't have a right to the environment in the Constitution, but we did have a constitutional amendment which introduced the duties of the state in respect of the environment. How does the state perform those duties? By coming up with laws. And those laws, like the Environmental Protection Act, the Water Prevention and Control of Pollution Act, etc., are the moments where we can deal with the death of the environment. Now, I don't want to give you the impression of this being a very rosy picture. It's far from it. Implementation has been problematic. There's a fundamental problem with formal law. We like to include and exclude things. Everything that's excluded does not matter, so the environment outside can continue to die. What is included is then subject to pull and push factors, of course. But because there was this duty of the state in respect of the environment, which is a non-justiciable duty, which means you can't go to the court and say they're not performing the duty, make them do it, there is also a constitutional environmental duty of the citizens of India to protect the environment. The Supreme Court at some point said there is a duty of the state, there is a duty of citizens, we have a fundamental right to life, let's bring it all together to recognize a right to environment into that right to life. So we have this basic structure, if you like, within the Constitution. I mentioned some of the environmental laws which could have that moment, the Environmental Protection Act, the Water Prevention and Control of Pollution Act. The problem is, on one hand, they are limiting because of the inclusion-exclusion. They do provide for fines or imprisonment, so use of criminal law, if you like, to punish the wrongdoers. But unfortunately, what has happened in the last couple of years is we've had amendments to some of the environmental laws in India, which has led to decriminalization, which means that we're no longer going to offer imprisonment as a penalty. There will be fines. Imprisonment becomes a last resort. Somebody was mentioning earlier about a version of the polluter pays principle. This leads to the situation where as long as you can pay for killing the environment, you can go on and on and on. And this was, I should read, this was done because it was said that, let me find the quotation, it was something about the ease of living and doing business. Okay, so the ease of living and doing business, obviously both very anthropocentric. But so there is this issue of, on one hand, having environmental laws, but on the other hand, having decriminalization. So on one hand, we're talking about a crime of ecocide, but the reality is we're having decriminalization of environmental laws. And the reality is we are also diluting environmental impact assessment laws. Yeah, so, which is kind of the ultimate safeguard, if you like, procedurally, that hopefully, if nothing else works, we can at least not prevent the project from going forward, but we make sure that the developers take environmental factors into account. So we are faced with the reality where on one hand, we have the planetary crisis, on the other hand, we have versions of authoritarianism, we have nationalism. So there is this balancing act, and I think we really need to think about how the crime of ecocide is going to be understood and applied in that context. So that's environmental law. Companies law. Now, in the UK, we've had some interesting developments. So, for example, Faith in Nature has now got nature on its board. And arguably, in India, the issue is that the director has to be a natural person. But one could say that we could perhaps think more creatively about how companies law could also be evolved, right? As a site for criminalization of certain actions if the companies don't hold their actors accountable. The other thing which is talked about a lot in the Indian context is the role of courts. Now, in the classic separation of powers system, the legislature makes the law, the executive implements the law, and the court interprets the law. So actually, there is limited room. But what the courts have been doing in the last few years is they have been acknowledging that this idea of ecocide has gained tractions in other parts of the world. And we have plenty of examples of how the diffusion of ideas has taken place over the years. So there could be a possibility over time that we might have, an activist court which might actually say a bit more. Now, of course, that needs to be taken with a pinch of salt because we need to think about, how that actually plays out. But it seems that ecocide has definitely entered the judiciary's imagination. So there is a possibility in the future, perhaps. So very finally, I think, and I'm very happy to take more discussion and questions on this, is really the question firstly. Krishni made the point in the morning about legal recognition of ecocide as a transformative tool for accountability, and I think that is really important. But we also need to think about what that means. Do we want another law? Do we want an ecocide law? So more law when existing laws are not working very well already? Do we want to think about amendments of existing law, or at least prevent the dilution of existing law so that the little protection that is available doesn't vanish itself? We also need to think about trying to achieve ecocentric objectives through anthropocentric law by adopting an accommodationist approach, amendments, etc. Or do we want to be disruptive? Is it possible to be disruptive of the law in some ways while ensuring that some existing law is still kept, because we do need to ensure some law and order, especially in a time of authoritarianism, nationalism, etc. And then finally, also kind of really thinking about where are the pressure points. And I think this goes back to the point that was made in the morning, which was about the role of formal law and the recognition of a crime of ecocide, right to a healthy environment, rights of nature in formal law, versus also thinking about the other opportunities where one can go to your local politician, where you might be able to exert more pressure, protest, non-violent protest, but of course the possibility that sometimes other mechanisms may need to be adopted. I'll stop there. Thank you for listening.
Let me introduce our second panelist, Dr. Matthew Gillett, who is a senior lecturer in law at the University of Essex and a UN special mandate holder, serving as the vice chair rapporteur of the UN Working Group on Arbitrary Detention. Dr. Gillett's distinguished career serves as a prosecution trial attorney and appeals counsel at both the International Criminal Court and the International Criminal Tribunal for the former Yugoslavia. And is also the author of the award-winning 2022 monograph, Prosecuting Environmental Harm Before the International Criminal Court. And he's going to talk about human, all too human, the anthropocentricization of ecocide. I'm going to let him tell you all about it.
If you are like-minded with Shakespeare, Henry VI said, first thing, let's kill all the lawyers. I have to apologize to you as well, because this will be quite legalistic. To a hammer, everything is a nail. Having worked at these international courts, I tend to think through that framework of, is this justiciable? Is this operationalizable? That's an unwieldy word. In the confines, in the structure of the International Criminal Court. With that, I did want to say a quick word of thanks to the organizers, and Damien, Kate, all the other organizers, and the publishers, and the institutions for having us here. And thanks to all the speakers. It's been fantastic. To all of those who've published in this collected edition, I know how much work goes into these things. The bad news is, as you get older like me, it doesn't diminish. And if anything, there's more work, more drafts. I think there's probably 20 drafts that I had of this paper. And that's just the way it is. But when you nurture it, it usually is something that you look back on with pride and can be glad to have produced and glad to have got the opportunity to produce. So with that, on the approach in this article, the main thesis I'm really presenting is that we need to preserve space quite diligently for the environment per se, not the environment insofar as it affects humans, not the environment insofar as we enjoy being in nature and seeing beautiful sights and being aware that there are pandas walking the earth, but nature purely in and of itself. And in presenting that point, I try and look back at some of the early thinkers in this area, like Richard Falk, who conceptualized ecocide as specifically protecting the environment, in addition to also having the impact of protecting human interests where they are impacted by environmental harm, but at its primary point, to protect nature in its essence. And my entreaty is to be cautious of overly opening up the definition to anthropocentric interests, albeit with beneficial interests in mind and trying to protect humans, particular groups, because unfortunately, I think as most would accept, humans have a habit of dominating areas that they get involved in, and human interests, I think there is a serious risk, may have the habit of dominating if they get introduced into this definition. In the article, I go through a number of areas in which this could manifest, but the primary underlying conceptual point is really that when we look at why environmental harm happens on a large scale, particularly in an organized manner, and I think that's the type of environmental harm we're concerned about. I mean, I can think recently a couple of idiotic gentlemen, I was going to say, but gentlemen in the UK went and chopped down a historic tree. Now, that is a crime. It's probably not the type of crime that the International Court is going to designate one of its few trials per year to addressing. I think we're thinking much more along the lines of course, Saddam Hussein lighting 600 oil wells on fire in Kuwait back in the early 90s, or large-scale dumping of hazardous wastes, such as we had in Côte d'Ivoire by this Trafigura company, similar events along these lines. And you could also think of the destruction of the Kakhovka Dam in Ukraine in 2023, the inundation of large areas, many ecologically sensitive areas. That's much more the type of issue that we're looking at. Now, where that happens, and I think we had a really excellent paper and exploration of mens rea earlier, Sabah. My view, anecdotally, but I'm seeing research to back this up, is that it's very rare that humans have the purpose of harming the environment, of sort of a hatred, animus malus against the environment. It's much more regularly arising as a result of disregard or deprioritization. So my concern is that as we introduce human interests into the definition of ecocide, one way or the other, it symbolically sends this message that environmental harm only matters if human interests are impacted, human physical well-being or their property. And that could perpetuate precisely the mindset that leads to environmental harm of the kind of scale that we're concerned about. So it's that unintended consequence that I'm mainly concerned about. And we've seen an example from the very innovative and really, I find, excellent work of the Jurisdicción Especial para la Paz, the HEP in Colombia, and they've noted in macro case number 5, it was quite interesting, and I highlighted a quote here, that this is coming from paragraph 494, that on paper, the guerrilla organizations, FARC essentially, described itself as an army with deep environmental convictions that even prohibited indiscriminate felling of trees, but in the heat of war, the reality was quite different. Whether actively or passively, the guerrillas' command structure was complicit in illegal mining and the expansion of the illicit agricultural frontier. These activities have left a drastic mark on the environment, one that will likely take generations to erase, and that should serve as a sober reminder of the environmental crimes committed there. To me, that encapsulated this concern that an entity which may have been well-minded towards the environment, may have seen that as part of their identity, but when we're distracted, whether it's war or a profit motive or potentially wrong-mindedly trying to protect your group, you may forget about the environment. You may think, what is the real harm in, or where is the benefit to us of dedicating our resources to this entity? And so with that in mind, when we think about a 5th crime added to the Rome Statute, we cannot ignore the existing crimes. So we do have war crimes, which are anthropocentric almost entirely. We can debate Article 8.2b4, which we've referenced to, as it mentions the natural environment. I personally think it's somewhat anthropocentric in that it has this balancing equation, but all the rest are very strongly anthropocentric. Crimes against humanity, it's eponymous, it's in its name, they are directed at protecting humanity. Genocide, obviously. Now, aggression is an interesting one, but it's not directly seeking to protect non-human or non-human created entities. I mean, the state is a classic intersubjective human creation. So they are all anthropocentric, and there's nothing wrong with that. That's a very good thing, and they should be used. If indigenous groups suffer, as they have in many contexts, let's use crimes against humanity, persecution, forcible displacement to prosecute the perpetrators. What I warn against is, therefore, motivated by the same concern, somewhat anthropocentrically diluting the ecocentric focus of Ecocide. And as a final point, one of the reasons that I do have this concern is I was involved representing New Zealand back in 2010, the negotiations in Kampala for the crime of aggression. And we're at a similar moment now where a crime has been proposed, it's being considered by, as we've discussed, this somewhat opaque working group on amendments for the Rome Statute. And at this moment, I think it bears recalling that the negotiations over the crime of aggression resulted in an imperfect formulation. Now, I think still an argument made that it was a good thing that was adopted, but certainly restrictions that came through, particularly the requirement of aggressor consent, aggressor opt-in to effectively be prosecuted for their own actions, was a fundamental issue, which has, as not many people foresaw, come into strong relevance with the 2022 full-scale Russian invasion of Ukraine. So at a similar moment of negotiation and formulation of a potential fifth crime, I think it bears, keep bearing in mind the fundamental nature of Ecocide, what it is, what it already exists, and how we want to shape it to fulfill the aims that we as a society, we as a humanity, seek to protect. So with that, thank you very much.
I'm going to introduce our next panelist, Darryl Odonkor, who is a lawyer and researcher with the Centre of Criminology at the University of Cape Town, where his work explores the intersection of criminal law, human rights, and social justice. Darryl's current research focuses on Ghana's illegal gold mining crisis, locally known as, now, am I pronouncing this correctly? Galamsey? Yep. It examines how legal frameworks can respond to the complex relationship between environmental harm, human livelihoods, and development needs. And he's going to talk about proposing a hybrid definition of ecocide. Let's hear from Darryl.
All right, good afternoon once again, and thank you all for staying for the graveyard shift. I'll try and keep this as brief as possible, just so that we can have a lot more time for discussions. As mentioned, I'm Darryl, and I wrote this paper, Weird Story. The idea came while we were drinking wine and discussing Prof. Gillett's book with my first co-author, that's my mentor, Dr. Odonkor Antonio, and my colleague, Mordecai Amici. And so the idea really was that all of these definitions that we are seeing, especially the arguments against the Anthropocene and all of those things, seem very egocentric. And so how do we then deal with this issue of ecocide in a country like Ghana, which has, a very, very extractive-dependent economy, to the extent that you have 1.1 million of its citizens engaged in this illegal gold mining trade. You have more than 20% of our country's GDP coming from the extractive economy, which then results, again, in environmental destruction on the one hand, balancing that against the need to protect the environment on the other hand. And so in this next 6 minutes, I'll try and propose a new definition, weirdly enough, based on all of the discussions that have been had today, to see how we can take the next step towards having a new definition as opposed to just leaving it at discussions as what should be in there and what should not be in there. Now, a lot of the points that I'm going to make have already been made, and so I'll just quickly zoom through them in the discussions. But essentially, this is the roadmap for the discussion. We'll start with an analysis of Ghana's illegal mining crisis, where I just give you some form of a background. The second part I won't spend a lot of time on, which is a review of the current definitions and the issues that have arisen because they've been dealt with a lot. And then third, which is the most important part, I'll show what our proposed definition looks like. And then we can open up for discussions on what should be in there and what should not be in there and why we think certain things should be in there. But just essentially by way of conclusion, we argue that a definition of ecocide should actually include, in opposition to Prof. Gillett's position, a balance between human rights and environmental protection, especially within the context of third world countries. And the reason that we argue that is, as Prof. Bhullar had said, that the one characteristic that you see in a lot of third world countries is this intrinsic relationship between human rights and the environment. So that we consider the environment as having its own personality, but for the purpose of providing for us. And in return, we are supposed to take care of it. And so it is not an either-or relationship. It is an and relationship, where one essentially relies on the other. And based on that, we would argue for our definition. So this is just a brief scenario of what is actually happening. The first question that I would want to answer is, why should we consider ourselves talking about Ghana? And I have two brief answers to that. First, just like a lot of southern states, Ghana has a very extractive economy, as I've shown. And so the issues that are seen here cut across a number of states, most significantly South Africa. And funny enough, these two countries are the largest gold producers in Africa. And then secondly, we present a different dimension from what has been discussed here. All along, the discussions have focused on the role of big corporations in this illegal mining and what big corporations can do. In our country, a lot of the illegal mining, for want of a better word, is carried out by the indigents. And so you have the indigenous people now who are carrying out the actions that end up polluting the water bodies and things, as opposed to big corporations. And so discussing big corporations is easy because you can say we can find them, ask them to repair the environment and all of those things. But how then do we start making those same discussions when we are talking about the indigents who live in those areas themselves? They don't have the means of the big corporations, but they are doing the same damage or even worse. So what do we do then? How do we deal with that situation? And so when it comes to the mining situation, it's just broadly two. We have large-scale and small-scale mining. The big corporations handle large-scale mining. We have smaller corporations and smaller individuals within the country handling the small-scale mining. Now, the only reason we are focusing on artisanal mining, that's the small-scale mining, is what I have just explained. Now, under the small-scale mining, we have basically two regimes. The first is the licensed small-scale mining, and then the second is the unlicensed small-scale mining. Now, illegal mining cuts across both. You have licensed operators who are doing the mining in a manner which their license do not allow. What do I mean? They go in, use mercury to dig up the water, wash all of this thing in the same rivers that eventually you are going to drink and use to water our crops. And then because they have the license, they are able to sell to the states. Right? And so they have actually acquired the gold, but the manner in which they have done it is such that they have destroyed the environment, and that's what makes it illegal. For the second one is obvious, no license, improper mining. And so you realize that of the small artisanal mining scale, research shows that about 85% of them carry out illegal mining. We have about 1.1 million individuals within the country. That is not big corporations that are engaged in this galamsey. This has resulted in about 60% of our water bodies being polluted. And so we have this thing where we laugh that every other month, the Ghana Water Company comes up with a new bill saying that, well, we can't afford to treat the water for you to drink anymore, right? The turbidity levels are nuts. So you see, for example, that the actual turbidity level that is prescribed is 4 NTU. What we currently have in Ghana is about 14,000 NTU. And so you have to use a lot more chemicals to treat the water for everybody in the country to drink. So now you start seeing a situation where the provision for protection of the environment is intrinsically linked to our human rights to a healthy environment, our right to water, and our access to life. And that's the reason why we argue that based on all of these factors, a hybrid definition would be better. All right, one last thing in relation to this human rights catastrophe is the bit about the fact that weirdly, a lot of these areas where these things happen is the same areas that we have a lot of farm produce coming from. And so they use this polluted water on the crops, and current research has shown that a lot of the crops that are coming out of these areas now have high mercury content, and so because of that are not good enough for consumption. So we are not only destroying our water, we are destroying our food. And again, it's not the big corporations. Great. So the next part that we'd really discuss is the current definitions that have been brought about which we have already discussed at length, and so I won't go too much into it. First being the UCLA Promise Institute's definition that came out in 9th April 2021, followed by the IEP's definition, which we have critiqued at length, and finally, Prof. Gillett's own definition that he reiterated in his book. All right? Now, 3 fundamental points arise from all of these things, it cuts across. And the first issue with it is the fact that there are vague standards. This has already been discussed, especially within the definition of what amounts to wanton destruction. Now, practically, why I'm saying there are vague standards is you look at a situation where, as a country, we need to be able to mine because essentially our GDP depends on it. And so it is not in doubt that we need to access the natural resources. Unfortunately, the largest bauxite mine, which has been discovered in Ghana, which, if we mine, would make us the largest producers of bauxite in West Africa, is in a protected forest area. They are agitating against actually harnessing it. But you have the problem where, as a state, a large number of your people need to have access to jobs. You need to be able to get money to provide for your citizens. But you also have to deal with these environmental standards. And so the question is, what amount of mining is appropriate? What will amount to wanton? And there's one thing about the law, which I always say that the most important thing about the law for me is its communicative function. All right? You should be able to signal to the individual that you are criminalizing that these are the actions that are not allowed, and these are the actions that may be allowed, so that if we are carrying out our affairs, we know exactly what to do and what not to do. Leaving it as vague as it is now doesn't do that. And so we are struggling to be able to determine what is rightful and what is wrongful. The second is the colonial implications. Obviously, the issue of kicking away the ladder, which has been discussed at length. And finally, which I have mentioned earlier, the human rights gap that these definitions do not bring. Now, this vague standard, the UCLA and Prof. Gillett tried to address it by bringing in certain enumerated acts, which, if you, as the UCLA definitions would show, we will have a catch-all clause in there that A, B, and C, and D are the acts that are prohibited and other related acts. And so what we did, effectively, was that we put all of this together in our hybrid definition. And so this hybrid definition, essentially, the core principle, as you can see, is that environmental destruction and human rights, especially within the context of third world countries, are interconnected, and we ought to address them together. All right? Doing this gives us a certain strategic advantage. And so on my flight here, I was reading a paper by Damien in Critical Defense of Ecocide, where he argues that there is a point that you need to be able to make in relation to states adopting this particular treaty and domesticating it. Because if you have this as an international treaty, international obligation, as Bhullar has, for example, mentioned, India is not a party. So does that mean that India has no relations to it? And so you want to make this a law that even non-state parties will be able to adapt within their economies or within their countries. And that is what this definition sort of provides. This framework of using human rights to protect the environment is proving to be successful, especially within the African Court of Human and People's Rights. We have SERA, we have OGIEC, we have WIWA and Shell. We have a number of decisions where this framework has been used. And so it's not anything new, all right? It just builds on what already exists to be able to get to where we want to go. And so, yeah, the point of the presentation. This is the definition that we're proposing. So first, the initial definition at the top, ecocide means intentionally or recklessly. The points that you made earlier about the mens rea for ecocide, I agree with the recklessly, really. Committing acts or omission that cause severe or widespread or long-term damage to the natural environment. So that part is covered. Where such damage, 1, substantially disrupts essential ecological functions, biodiversity and ecosystem services, and results in or creates substantial likelihood of harms to human health, safety, livelihood, and all of those things. So that is essentially the new definition that we are proposing, which bridges the gap between environmental ecological protection and the human rights angle. Now, to deal with the issue of the vagueness, we have included some enumerated acts, which are destruction of protected ecosystems, large pollution of the air, trafficking or dumping, systemic forestation, and then other acts or omissions of a similar character. For those who are experts in international criminal law, we know how controversial this particular provision is, because the argument is that it must be interpreted ejus dem generis, which means that if any of the new acts that come out do not fall within any of these four, the argument can be that it should not fall under other enumerated acts. But this is open for argument and it's open for debate, which I hope the questions will bring out. And then, most importantly, we have included a positive obligation, or a positive, yes. So what is lawful? Rather than stating only what is not allowed, we have included which kind of mining is allowed, which kind of environmental exploitation is allowed. All right? And our proposal is this, that the definition will not apply to acts conducted under legally authorized, scientifically validated, sustainable management practices because of the elements of sustainability, provided that such acts include measures to prevent, mitigate, and remediate environmental harm. So we take it a step further from the UCLA's definition, where they argue lawful, right, to say that, well, lawful conduct should be allowed, to actually provide what's within the context of the discussion should amount to lawful conduct. There should be legal authorization from the states. That legal authorization should not exist in a vacuum. It should be scientifically validated. Sustainable management practices should be included, including such acts that or measures to prevent, mitigate, and remediate environmental harm. Part of this is also coming from the point that the environment will be affected, definitely. As long as you are going to extract resources, there will be some amount of harm that is allowed, all right? But if you take all of these steps towards sustainable management, among other things, then the goal is, yes, eventually we'll be able to get to where we want to get to, protect the environment, while allowing human beings to also access those resources for development. So just the final bit on what this does for countries like Ghana. Again, back to the point that I made about the communicative function of the law. The government can now pass such a law because it takes away the argument that you are telling us not to mine altogether. Because that has been the biggest pushback against the Galamsey, right? The people argue that this is our means of livelihood and the resources are in our land as indigenous people, so we have the right to access them. So you passing a law that says that you can't access them at all is essentially infringing on our rights. Now, with this kind of law, we are communicating that it is not that you are not allowed to do it at all. It is just that if you are doing it, these are the measures that ought to be taken into consideration. And mind you, not 100% of the artisanal mining is illegal mining. We have about 15% that actually follow what they are supposed to do, which means it is possible. All right? So rather than passing a law that outright bans exploitation of the environment, you are able to communicate to the individuals that, yes, this is the situation, and you'll be able to now get the buy-in towards the goal that you want to achieve at the end of it. All right? Now, for the intent or recklessness, obviously, that has been met, environmental damage, the human impact, and it doesn't fall within the exemptions. And this is the reason why the current Galamsey situation would best fit under this particular framework or this particular paradigm. And so, in conclusion, these are some of the advantages that we think that adoption of such a paradigm would bring. All right, again, back to the point that we have a lot of third world countries that have very extractive economies, and you want to be able to make provisions for them, to be able to identify that, yes, you are allowed to mine, you are allowed to access your resources as a country because obviously arguments of sovereignty and things exist, but these are the parameters within which those are doable, and if you do it within these parameters, it should be fine. Once we do that, we think that as one of the tools within the larger toolbox of what have been discussed so far in relation to restorative justice and all of those things, we'll be able to arrive at the destination that we want, where the environment is protected, but humans also benefit from it. All right, thank you very much.
Thank you, Daniel. And a fellow from Global South, I can certainly relate to what you were saying, because it's not just big corporations who do damage to the environment. Sometimes it is ourselves in those smaller countries. For example, in the Maldives, we are in archipelago, and we need our islands are very small, and we need to develop them for tourism, which means sometimes destruction of coral reefs. We have the largest seaplane fleet in the world, which contributes to carbon emissions. But again, if you can't sail into the Maldives and develop tourism, and most of our foreign income comes from tourism. So I'm totally seeing it from a global South perspective. But we have a very interesting next panelist here joining us online. Yes, can we have? Joining us online is Professor Darryl Robinson, who is a professor of law at the Faculty of Law, Queen's University, Canada, and a member of the Ecocide Law Advisory. He's one of the leading scholars working on the intersection of international criminal law, environmental protection, and human rights. And his distinguished career spans diplomacy, academia, international legal practice. He served as a diplomat. I have to say this, being a former diplomat. He served as a diplomat with Canada's Department of Foreign Affairs from 1997 to 2003, where he played an important role in the negotiation of the Rome Statute of the ICC. And he's going to talk to us about humans matter too. Ecocentric does not mean misanthropic. And we're going to hear from him about the use and the misuse of the terms anthropocentric and ecocentric that has emerged in the current ecocide debate. I can't wait to hear what you have to say, John.
Can you hear me okay?
Yes.
Okay, all right. I made a PowerPoint. I'm not a PowerPoint person, but here we go. Let's see if it's showing correctly. Let me make it go slideshow. 1 second. There we go. Is it a nice, pretty PowerPoint? Hang on. Is it a nice PowerPoint on the screen right now?
Yes.
Okay, good. Okay. So yeah, hi. It's nice to see you all, even though you're pretty tiny. I wish I was there. It sounds like a really good group. I'm going to make what sounds like a pretty wild claim, which is that within the ecocide conversation, we're widely misusing the terms anthropocentric and ecocentric in a way that's demonstrably incorrect. It started with a virus, like a virus right from the first blogs. And my point's not just a little pedantic one. The misuse is leading to prescriptions that are scientifically uninformed and or ungrounded and ethically untenable. So let's jump into this. So the common misuse in my article, I give dozens of examples. People use the word anthropocentric as if it just means human related. So some of the recurring things is I give lots of examples in the article of people asserting that any consideration of human well-being, interests, or harms is anthropocentric because of this idea that anthropocentric means human related. Any possibility of balancing human and non-human interests is routinely described in the literature as anthropocentric, and it's commonly said that an ecocentric provision has to be absolute and make no allowance for human interests or use. That's probably all familiar to all of you because you know the literature. Meanwhile, environmental ethics, anthropocentric doesn't mean caring about humans. It's a specific view that only humans matter, that humans are at the center, and we only protect the environment for present or future benefit of present or future humans. Ecocentrism, by contrast, is concern for all living things. But here's the key thing, all living things includes humans. Humans are living creatures, and they're included in, right? I hear people agreeing with me that humans are living creatures. I give lots of quotes in the article, but ecocentrism expands the moral community, so it's not only about humans, we are also concerned with non-human life. So there's this contrast, the way it's presented in the ecocide literature is if they're in diametric opposition. The idea is ecocentric is only non-human nature, and any reference to humans renders the thing anthropocentric. Meanwhile, the actual relationship between the two is concentric circles. Anthropocentrics care only about humans. Ecocentrics care about humans and non-humans, so it expands the circle of care. And again, crucially, neither of these positions excludes human beings. I give lots of other quotes in the article. So at this point, you might think, well, okay, fine, I care about humans, why should we ever allow humans to have impact on nature? And there's this common thing you see in the literature that any human impact must be short-sighted, selfish, anthropocentric. But that's not engaged with science, and ecocentrism engages with science. It's a matter of biology that all living things, including humans, have to draw from the environment or they die. And likewise, physics, all the material that you use, the food that you eat has to come from the environment. The clothes that you're wearing came from the environment. The chairs that you're sitting on came from the environment. The room that you're in right now was built out of materials from the environment. The screen that you're looking on right now, that came from the environment. So it's not just a simple matter of, oh, let's just ban humans from having impacts. It's a much more complicated story. Humans have to use the environment to live, but we also have to preserve and respect it. So there's this complicated tension. And that's why ecocentrism doesn't absolutely preclude impacts. It's about proportionality, justifiability, from a holistic perspective that's not human-centered, but just looking at the whole system, including humans. And how do we transition to a sustainable society? Another short way to explain this is I could put these two propositions. Only humans matter, or I could say humans matter. The first one is anthropocentrism. The second one is ecocentrism. It's also all plausible ethical theories. I'll skip this bit just to keep myself humming along here. I can sort of demonstrate this with this little chart, but hopefully you're all getting it now. I can put three attitudes: caring only about humans, caring about humans and non-humans holistically, or excluding humans. And then I can show you how the literature. So the Ecocide literature correctly calls caring about humans only, that's anthropocentric, that's correct. But caring about both humans and non-humans, the Ecocide literature calls that anthropocentric. I give a jillion cites in my article, but that's not correct. In environmental ethics, that's ecocentrism, caring about all things. Meanwhile, in the Ecocide literature, this position of excluding humans, which, again, people, commendable, well-intentioned, but they think that's the ecocentric position, we have to exclude the humans, but that's not. In fact, that position is what ecocentric scholars in environmental ethics, they call that position misanthropic. It's misanthropic because you're excluding one species, the humans. So I give lots of examples in the article, just but actual ecocentrism is not misanthropic because we care both about human and non-human nature. And they warn against this recurring pitfall that people say, oh, I want to show I care about the environment, so I exclude human interest. And they warn that position is misanthropic and should be guarded against. Other people talk about this common misunderstanding, and it's a pitfall because it leads you to go, oh, nature good, humans bad, and it treats humans as if they're strangers in the world, but we live here. It's our home as well, right? I could give other examples, but you get the gist. Ecocentric scholarship from environmental ethics literature is scientifically informed and human inclusive. I have lots of examples in my article, but they know obviously ecocentric laws have to allow some human interference because, like all creatures, we have to survive. And to survive, that entails having impacts and making use of the environment. Earth jurisprudence is one progressive kind of ecocentric ethics. And even there, they say, listen, even on a rights of nature approach, even on our rights of nature, you can have competing rights, and sometimes you have to balance competing rights. That includes the rights of the humans. So human interests might still prevail even under an ecocentric holistic assessment. You might say, well, this is a really vital need that humans need to live. Deep ecologists are another kind of progressive ecocentrics, and even they say, yeah, sometimes humans are going to have to harm biodiversity to protect their own vital interests because of just the empirical conditions of existence. There's another one, Milius. He wrote ecocentrism, it's not just a matter of turning the tables so that before humans always were on top. We don't just flip it so that humans are always on the bottom. That's no good either. It's about finding this holistic balance. So that's the gist, the conclusion. So my big message for you, and I've already heard at the conference people using ecocentrism and anthropocentrism in the unusual ways, but ecocentrism includes human well-being. So some of you already described yourself as like hybrid or in between, but you might be ecocentrics. So it includes human well-being and allows human impacts. The current ecocide debate is a bit overstated because it's gone off the beam in how it's using this. It's too strident in rejecting any accommodation of humans. And we need the literature to engage with the science of survival, how do humans stay alive, and environmental ethics. There's a couple objections people might be thinking right now. The first one is you might think, well, okay, that's all fine. I care about humans. But how can, ecocide is about severe harms. So how can severe harms ever be okay? That involves a bunch of empirical questions that are so separate. I actually have a separate article on those ones. But the short version is there's 8 billion humans. They all have to have a footprint to live. Sometimes activities that serve hundreds of millions of people have a quite huge impact. And this is the upsetting hard part, is we're often in these situations of making hard choices between harmful things, including the harm of, oh, we'll just let the humans die. When you look at all the possible options, some of these are the least harmful option, even though, you know, it's a terrible predicament we're in. Another thing, and I agreed with what Matt said, the fear that the humans are going to dominate, if we make a balancing test, the humans might dominate. I think that's a totally legitimate concern. And for that, we maybe need to still refine the definition. But my point for us is I'm pushing against the biggest obstacle in the literature, this absolute exclusion of humans that people think they're doing in the name of being ecocentric. That's not ecocentrism. And the conversation has to continue on the basis that human suffering and well-being are totally legitimate topics. Thank you.
So much, you know, that's fascinating. You know, we've had wonderful views about all this, so I'm going to just straight away open the floor for any questions. Then I have some myself, but I'm going to keep it for later. Can I see any hands here? Any questions? Yes, please, go ahead.
Well, thank you all. It was really such a brilliant panel, and I think that you all come together so interestingly. But I would love to ask Daniel and Matt to reflect on what Darryl said, because I feel like he relates to what both of you said. I mean, actually also to Lovleen. But I'd love to hear the panel reflect on Darryl's strident intervention in favour of humans.
Sure, and great panel, by the way. It came together very well. I really enjoyed especially the theoretical discussion, Darryl, that you provided. I guess it's a question. As you were talking, I was thinking, how does this translate into the context of the International Criminal Court, specifically under the Rome Statute? Because if I step back and think about, as it currently stands, the Rome Statute seems anthropocentric in the sense that there is no provision for the environment. I mean, let's put aside Article 8 to B4 for the meanwhile. But it's overwhelmingly anthropocentric. And so if we add in a provision that does, let's say, give priority to the environment, and we can discuss how it gives priority. I think that's what you were getting to at the end. The how is quite a difficult question. Are we therefore rebalancing in a more, let's say, not equal, but more inclusive way? So we'd have 4 crimes that are essentially anthropocentric, one that you could say is, depending on your definition, ecocentric. So that was a thought. And then the other thought, and this maybe is a fault of being sort of practical-minded, maybe less than theoretical, is when I think about a person sitting in a high-rise apartment 100 floors up in Manhattan and they suffer harm, is that really ecocentric harm? I mean, if ecocentric is everything, is it therefore nothing? And And I suspect the reason people are using the term ecocentric as a sort of colloquially is because they are thinking of harm to nature, harm to natural entities, as opposed to, even very serious offenses, genocide in Srebrenica. You wouldn't immediately think of that as ecocentric harm. So I think that's where maybe the practicalities conflict with the more potentially scientific definitional approaches. So those are some immediate thoughts.
I'm going to let Darryl come back on that, if that's all right.
Oh, okay. Already now? Yeah. Let's think. So first of all, I think I agree that the Rome Statute crimes, they're anthropocentric. They're all concerned with humans. I think there's no barrier to adding an ecocentric crime. That's fine. Much like when aggression got added, everyone said aggression is different from the other three because the other three are about violence. So there's no reason, there's no deep schema that stops one from adding new things into the statute. So that's fine. I guess I don't agree on this divide you're drawing between theoretical and practical. I think I'm a very practical person. And I think that what I've shown here about definitions has very practical outcomes. I agree with you that a lot is going to hinge on how it's defined. I take your point about a person in an apartment in a city, and you're seeing them as somehow, they're humans. The person in an apartment in a city is a human being and is included within ecocentric compassion. So I think that all humans are included in ecocentrism, and that includes apartment dwellers. I take your point, which is people are thinking about environmental crimes, but again, the contrast is just ecocentric means we're not caring only about humans, we're adding in all the non-human nature. So I think that's totally consistent with the correct use of the terms. So yes, we're expanding it to include non-human nature, and that is ecocentric.
Daniel, you want to come?
Yeah, so I think our papers align, not necessarily in relation to the science, but to this extent. We both see nature and human as one whole, as opposed to two separate entities that exist independent of each other. And in our paper, we even argue it because if we are arguing from a third world perspective, we argue that if you look at African cosmologies, for example, and I think I'll take a point from the river goddess, for example, in relation to India, we always have had this symbiotic relationship with the environment, where we deem humans as a part of the natural environment, so that we both rely on each other, one relying on the other. And even speaking to the science, a good example would be the flow of oxygen and carbon dioxide in the atmosphere, right? We breathe it out, the environment takes it in, it gives us oxygen, same as other animals. And so I don't think our points are misaligned. I think we are actually speaking to the same thing. Probably use of different terminologies, but at the heart of it is essentially the same thing. That when you are speaking about protecting the environment, you are speaking about it as a whole. One, including human beings, and there's the need to protect both, not one or the other, as, for example, would exist within the current framing of the Rome Statute. But then what we are proposing is look at it from that holistic perspective, just as Darryl is saying, and let's make laws that approach it from that perspective as opposed to one or the other. So I think we are aligned, really. It's just a matter of how it's framed terminology, but practically we are speaking to the same thing. So I largely agree with him on that.
Thank you. Lovleen, do you want to come on that? But I have a little bit of addition to that, because in India, there's a lot of deep cultural and spiritual roots that relate to the environment. So would you like to comment on that as well, please?
Yeah, I just, before I do that, I was also thinking a bit about what we mean by ecocentric literature, because it's not one body of literature, and it's not just lawyers writing about ecocentrism or rights of nature. And because I agree entirely that ecocentrism, human beings are a part of nature, and what you just said, but there are different kinds of human beings, and I think there is one aspect is kind of how the literature describes anthropocentric or ecocentric, and second is what different human beings do with those concepts. And I'm not just thinking global north, global south, I'm also thinking about different kinds of human beings in the global south. So in our paper, we talk about how They could be indigenous communities, but they could be people living near the river, or people who just like to go to the river, or people who don't give a damn about the river, but just seem to care about a cause at a given moment. And I'm also thinking about the danger of thinking about the balancing act, and if human beings are, if you're going to say human beings are a part of environment, let's always think like that. I'm worried about the balancing exercise in a context where 7 of the 9 planetary boundaries have been crossed. And the risk of trying to balance at that point seems too high a risk to me. And also then thinking about basically about which human beings, where they are located. And the question of science came up because you were mentioning scientifically validated knowledge, and Darryl was talking about scientifically informed processes. And that also raises the question of whose science and where, where it's coming from. Is it including sort of traditional knowledge and traditional science? So my point really is, I see why it makes sense to kind of talk about, ecocentrism, human beings, the part of the environment, but I think we also need to do it a bit cautiously, because then in the hands of decision makers, it could become a tool for saying, well, we are a part of the environment. Every decision that we are making is made in that spirit, and here is the balancing exercise, and this time certain human beings win, human beings won, environment 0 always. And I think that's worrying. And I think that for me, that also links to the question you were asking just now.
Thank you. Anyone else? Yes, please, go ahead.
I think I have a related tension in the definition that you proffered with this sort of human involved in, with humans being involved in an ecocentric definition, which I think, agree with in the broader sense. I have the question of this proper balancing, and when you bring up specifically future generations, I think is the key to your definition, but we don't have a history of properly weighing future harm. And I think that's a key issue in any sort of cost-benefit analysis or balancing, and I'm curious what people have to say about how we consider the proper validation of those harms.
So I see your point, and 2 things. On the first step, yes, at least we can all agree that there's the need to conceptualize both as a whole, not one or the other. So that's done. Now, the big issue, which I mentioned during the presentation, is the question of how then do we do the balancing, right? Because early on at the break, we were talking about the fact that the economic balancing test that exists currently within the current framework is a bad standard. And so we can agree that we take that off. But then what else do we look at, right? We, for example, in our thinking, considered scientific knowledge. But as Bhullar has, for example, mentioned, whose scientific knowledge? Does that include traditional knowledge? My immediate answer to that would be yes. It should obviously include. But then the point is that in having these discussions on what ought to be considered when we are doing this balancing, rather than coming to the conclusion that because the balancing is difficult, let's stop it altogether and focus on either protecting only the environment from humans. We should rather come to the point where we are able to come up with some form of solutions that would essentially create that bridge that we are going at. And I know it's a form of Derridian aporia, where it's like these are 2 difficult tensions that you have to struggle with. They are tensions that exist that we need to be able to struggle with to be able to get to where we are. And so I may not have a direct answer on A, B, C, D, E, and F are the appropriate balances. What I can say is, based on the discussion, for example, we know the socioeconomic harm is not a good balance. We know we have to consider traditional knowledge as part of the scientific knowledge. What other harms may arise in this balancing act, and how are we able to deal with them? And if we are able to answer those questions based on the discussion that come up, we would probably approach the point where we look at being able to properly protect the environment and human, as opposed to just resigning to each other and saying, because it's hard, because it's difficult, let's not even start talking about the balance at all. I think that's a bad approach to look at it. So I think we are largely in agreement. The question really then comes to how do we then deal with the issues that have arisen, and it's up for debate, really. But that's what you have to say.
Yeah, thanks. I think hard cases make bad law, but in this area, you cannot avoid at a certain point the question of human interests, particularly in development, versus the integrity of the environment and environmental harm, because that inevitably is going to be the debate in some of these cases. And how you go about balancing this, to me, is a really core question behind Ecocide and how we formulate it. What I think, there's one approach, which is you just distribute it, delegate to the judges. Say, okay, judges sitting in The Hague, you guys decide, do the social economic benefits outweigh the environmental harm? And it's kind of a one-step process. I would advocate for a multi-step process where instead of leaving them such broad discretion, and I think there's also quite democratic concerns about a few judges deciding that for the whole globe, potentially, that you build on existing legal regimes. So you say, okay, in the area of natural heritage, the states of the world have all decided collectively, this is the regime, this is how we balance what certain sites, certain natural heritage, I don't know, Niagara Falls, there's certain, I think we saw from Jamaica earlier today, sites of profound importance to the international community. These should be protected. Similarly for the transport of hazardous waste under the Basel Convention, the trade in endangered species under the CITES Convention. So a lot of the balancing, a lot of the work has been done and codified into conventions. And the more, in my view, we can feed that to the judges and have the judges interpret and apply that to specific factual scenarios, the less they're going to have to effectively invent some kind of framework, or even worse, not even apply a framework and just pluck it out of the air. So maybe I'm starting a society for the safety of judges or something here, because every time I talk to judges from The Hague and they look at this, they're extremely concerned about where would they even start, what would they use. So I'm encouraging, let's build on the existing, and then democratically, as those regimes develop, the Framework Convention on Climate Change, etc., as they develop democratically, that feeds in to the application of Ecocide at the International Criminal Court or domestically, and it's much more accountable to the polity in a kind of in a loop like that.
Darryl, do you want to come on that?
Sure, thanks. I love this discussion. I like Lovleen's question, and to be clear, that's not my definition of ecocentric. That's the definition from environmental ethics literature and the environmental literature. But she's totally right. There's different camps. There's different kinds of ecocentrics. There's earth jurisprudence and deep ecologists. There's all kinds of nuances within the camp, but the general idea that ecocentrism is concerned with all of life is quite firmly established. I also agree with Lovleen, and ecocentrics are also concerned with justice between species and within species. So, for example, environmental racism and so on, those are concerns completely on the agenda for the ecocentric scholars. I totally agree with Lovleen and the other participant about how is the balancing going to be done. In the paper, I discussed that at more length. Here, I just did a little presentation introducing the terms. But there's a 100% legitimate question about how was the balancing going to be done, especially given the history of how humans have done the balancing. And for that one, that's the exact conversation I'm trying to get us into, is how do we do this balancing and how to put safeguards on it. And is the definition in the panel, is it too laconic? Do we have to put down more guardrails? Those are great topics. I'm currently simply responding to the conversation we have right now, where article after article rejects outright any accommodation of human needs, and I'm saying that's not okay. So in some way, the human survival has to get included. But I'm all for figuring out, doing a better job in making the balance clear, but there has to be some balancing. It's just, humans have to eat.
Thank you very much. Do I see anyone? I have a question for the panel, actually, Daniel, you might have some ideas about it. I'm sitting here, and I'm not from the legal background, hearing about definitions, law, ecocentric, anthropocentric, and in my language, there are no there's no translation of these words. So while we discuss all these definitions and the Rome and language, how does it translate to indigenous people? It's very well to talk about this in academic circles, and I totally agree that we need to talk about this and come to decisions so that we can take this forward. But how does it translate back to our own cultures? And I would really like to ask Daniel the question.
Yeah, thank you very much. And to add on to the question before I answer, there's this funny thing that usually goes on Ghana Twitter, where when we were protesting Galamsey, the people who were in the pits made videos and posted on TikTok and Twitter, and they were basically saying that you people sit in the capital and you make laws that you expect we that we are sitting in the villages to be bound by, and it doesn't work like that. And that unless you come and live the kind of lives that we are living, where we didn't have jobs, where all we had to do was subsistence farming, and now we have this thing that is giving us money, you have absolutely no right to tell us about Galamsey. And it's just feeds into the bigger issue of the point that I made earlier about the law not being the only answer. All right? The law essentially is just one important tool, but it's not the only tool. There are a variety of things that we can do aside just the passage of the laws. For too long, and I know why you're asking the question, because especially in global south countries, we pass the laws and go and sleep and say that we have laws that are supposed to deal with it, and so that's enough. But one, as you are saying, this is legal language, this is legalese. The person sitting in the pit who doesn't even speak English does not understand what it means. And so what does passing such a law have to do with this particular individual? All right, and it just goes to show that, yes, we need to pass the law for communicative function, obviously. We need to have the laws in place as a system of checks so that we have a standard that we are going with. But in addition to that, we need to work on one dissemination down to the grassroots, to the individuals that it actually affects. And even more controversially, we need to include them in the decision making, which goes back to Lovleen's point about in the discussion of scientific knowledge and indigenous knowledge, in the discussion of scientific knowledge, are we including indigenous knowledge? It's only when we bring the voices of these people into the bigger discussion of what we are trying to achieve that we'll be able to get to the ends that we want to get to. Otherwise, we'll have another situation where we'll just pass the laws and nothing will be done. And on the ground, the people will not follow it, and there's absolutely nothing you can. So basically, that's my answer, I hope, to the question that you asked.
I would like to bring Lovleen into that as well, because there's something in your presentation. You said that what can be done maybe perhaps outside the law, semi-legally in India, because India is not part of the ICC. And I was a political activist in my previous life, and India has several languages, hundreds of languages. So how do you see that working within the definitions we are talking about?
Linking into the question you asked, Daniel, earlier, I was thinking about how people, indigenous peoples or people who don't speak English or whatever understand, there's a sense of what is ours or mine and the otherness. And formal law can be the other to many people, right? Because they have their own legal arrangements. They are not formal legal arrangements, but communities, even the ones who might be engaging in small-scale mining, have their own arrangements. You don't do certain things. You don't go mining where someone else is going because that is their bread and butter. So those arrangements already exist, right? So it is the point at which that arrangement is disrupted by formal law. Sometimes it is that people come to court because otherwise they're like, we've made our peace. There are two parallel legal systems playing out. But I was thinking about the places where intersection happens. So one of the things we mentioned in the paper, because we were looking at it through the lens of rights of nature as well, is this discussion around restorative or reparative justice. And what is interesting is in a lot of countries, including countries in the global south, environmental protection laws tend to have a provision which is about a fund. There is some kind of an environmental protection fund. So in addition to decriminalizing certain offenses, the other thing which has happened recently in India is they have included a specific environmental protection fund. And let me just read out what it can do, because I think that answers part of what you're asking me. Bear with me, please. There is something about education, about achieving the objective of the law, etc. And I think that moment for awareness and education is really interesting because it links to your point about people not knowing what the law is, right? So, and we were discussing this earlier in the context of when people don't know that there is a law on ecocide, they will not realize when they violated it also. So suddenly you have someone coming to imprison you because it's a crime of ecocide and you have no idea why that might have happened. So I think provisions like that, where they are talking about restoration, can be quite powerful. The difficulty is a lot of these provisions for restoration say the government will take the lead on these projects, which means the government decides what's right for a particular community. So I think if we were to have more meaningful conversations, if people had more knowledge and awareness about the laws, I think they'd be able to engage more fully. So I think going back to a point made in the morning about procedural aspects, I think that is truly powerful. And we have known historically that we may not have made as much progress on substantive elements, but in many cases we have gone much further with procedural rights. And I think that's also true in this case.
Thank you. Do you want to add to that? Or?
I mean, I was going to add a thought about the, and I think it's an interesting discussion that builds on a lot of the points made today. Who are the victims of ecocide? And the environment, as in the natural environment per se, humans, are they the direct and or indirect victims? Which groups of humans? And I think at the moment, the Rome Statute system is imbalanced in the sense that only humans and human societies for, I think, education, charity, and cultural purposes are listed under Rule 85's A and B as potential victims. And so you'd have this incongruity where, let's say you could prove a crime against the environment, but the thing, as in the nature per se, that suffered is not able to be represented as a victim. And I think that could lead to a very strange outcome where some natural humans get some remediation, but the environment itself doesn't. Maybe you could use societies, NGOs that represent the environment as sort of human organizations. Maybe you could squeeze that in there, but it is strange at the moment the way it's formulated. So I think it's not a one-stop shop as far as let's just adopt the crime and it's done. I think there probably needs to be a review also of some of the rules of procedure and evidence at the same time.
Thank you.
And just,
sorry, please.
Just to pile on to the question of who are the victims, this goes to the point that Darryl made earlier about even as between humans, who are the victims, true victims of these environmental destruction. Because the indigenes that live in the area would argue that the river belongs to us. We are allowed to do whatever we want with it. So if it is just pollution, that's fine. But then the entire country depends on that river. So now the question is, who has the rights to it even? Can they do whatever they want to it because it's theirs? Is it something that because we all rely on, we need to take steps to protect? The point that you made is, how do you call it? I think exactly on point with Short's point that at the end of the day, what we really need to do is now rethink the entire ICC system and whether it is the best fit for a crime such as this. Because it raises the exact question that you are raising about the fact that victims are identifiable individuals. We are damaging the environment. How does the ICC accommodate such an issue? And so maybe as part of the discussion, we should consider having a separate statute. I don't know. Or probably making changes to other provisions in the Rome Statute to make accommodation, as you are rightly saying, for this particular position, as opposed to just passing the law and letting it go and saying that we've done what we are supposed to do. Otherwise, we really won't achieve anything. It will just be another pen to ink, closed book, and then we move on from there. So I completely agree with you on that one.
Thank you. Well, I'm going to give each panelist just a minute to say the final words, and I'm going to start with Darryl.
I have nothing to add. That was super enjoyable. It was so nice to see all these faces. Great questions. You're totally right. All the points everyone zoomed in on. It was lovely to join you.
Nothing really to add. It's been really amazing. I just want to leave like one thought because it's been on my mind as well, is your question about future generations. The definition of a generation, it's very clear we're talking about the human generation. And I think since we are talking about ecocide and a little bit about rights of nature, it might be interesting to think about the future generations of the environment. And I wonder whether, it's tricky enough with future generations of human beings, I appreciate that, but I wonder whether we could make it even messier, because that really kind of makes us think about this in a slightly more holistic and long-term manner.
I have absolutely nothing to add, except that it has been fun, it's been enjoyable, and I think the advantage or the fun part for me was a lot of the things that I was going to say was already said. And so it's a point that is usually made back home that when you're writing, you have to be in conversation with all the people who have written on the topic. And today, all the people who have written on the topic were here and we were all in conversation with each other. So it was fun, and thank you very much for the opportunity.
Matthew, you get the final.
Well, sure, I'm sure you'll have a couple of words after. But yeah, also I really enjoyed the conversation and the earlier ones. Now, I try and conceptualize, if we could have the environment represented here today, as in the natural environment, who would it be? And I think that would be really interesting if we had, whether it was the ecologist, ecology scientist, a zoologist, I don't know. It could be really interesting to hear what they thought. Maybe, especially from us lawyers, they might think that we're talking complete rubbish. And so, I in my research also do try and engage with other non-lawyers, and I think we've had a range of disciplinary backgrounds, but maybe at one conference we can have an advocate for the environment present to try and speak from that viewpoint.
Well, thank you very much to all our distinguished panelists. I think they deserve a round of applause, Tommy.
It's been so thrilling, personally, to see all of this come together and hear so many interesting glimpses into all the papers which you can all read. And we've come to the end of the day session. And as you know, we're going to have a reception, and then we're going to start again from 6 till 7:30 with more fascinating insights. So with that, I'll thank you and hand over to our actual host.
Well, thanks everyone for coming. It's been a pleasure for the Institute of Commonwealth Studies to host such a wonderful event. It's been fantastic to see so many familiar faces and lots of new ones. Let's retire upstairs to have some
back upstairs to the reception.
And hopefully some of you will stay for the evening.
Which kicks off at 6 p.m. Okay.